Hey, welcome to All Things Social Security. You're about to see a question from a live viewer and my response, and it may or may not have an attached additional set of information for you, but you'll see a little invitation to that if that's the case. If what you're looking for is representation and you want us to take a look at your claim, please go to joydisability.com and look in your upper left-hand corner for the link for the free SSD evaluation. And we will take care of that for you. Thank you so much. Bye-bye. Enjoy the video. Let's talk about evidence and discovery in Social Security and Social Security disability and SSI cases. It is definitely very different from state court. I used to practice in state court doing general practice type of things, personal injury insurance defense, matrimonial, those kind of things in a very long ago, different lifetime. SSD and SSI disability claims are under a different kind of concept. It's called administrative law. It doesn't have the same rules of evidence, and they are far more lenient in terms of what is admissible than what would be in state court. The admissibility rules of evidence in state or probably federal court, because we usually stem off of them, are very largely stringent, and there's so many forms of hearsay that are not allowed into court without barring some sort of exception. In Social Security disability and SSI cases, the discovery process runs by its own little administrative process. You file your application, and in your application, you provide the names of all the doctors with their addresses, accurate addresses, phone numbers. I know we like to collect fax numbers because it's far more efficient. And the first time you started there, the last time you were there, and what you were there for, whether they prescribed medications, whether they ordered any tests for you that you went and got. And when you have all those medical provider contacts in your application, when the field office gets the application, it doesn't do anything with them. But when it makes sure that everything that needs to be in an application, the technical requirements to be an application that can be processed, when those things are met, then they send it on to the next path, which is where you're going to see your step 3 and all that, the medical workup. And that's at your state DDS office. The acronym can differ. We always say DDS, but it's like Disability Determination Services. I've seen Disability Determination Bureau, I think. I mean, whatever, there's 50 states, so they all have their own verbiage. In any event, those are the guys and gals that use the medical provider list that you provided, and that's why they say be thorough, don't leave anybody out, and they order all those records. They do their best to do it. They can't guarantee they're in, and they don't have to go down and track down a doctor and go get them. So they are assisting you as part of their duty in getting your medical records to them. Does that mean you don't do anything? Some people seem to think so. I know a lot of you pro se's just are like, oh, well, I applied, so we'll see what happens. I'm like, well, how do you know if they obtain them? Now, when they request a doctor's set of records on you, and the doctor's office, it's usually not the doctor himself doing it. When they don't put out, they usually send, and I think this is part of their procedures. It might even be found in the POMs, not sure. They're supposed to send out, I believe, a second request, like 20 days later. And I think oftentimes at that time is when they're going to maybe pop out a letter to you saying, hey, we couldn't get the medical records from this guy. Can you please contact your doctor and make arrangements to get them? And that's, hint, hint, you might want to do that. If you're very diligent, you'll be calling your adjudicator and keeping in touch about what's missing, do they have everything, yada, yada. That is how the discovery gets in. It's everything you send. It's everything your doctors send. It's also your responses on the mandatory, pseudo-mandatory reports, so the function report and the work history report. Those are all pieces of evidence. And the function report is where you're describing your subjective viewpoint of how you feel and how you're limited and all that kind of business. It's not a medical record. It's a statement from you. That too is evidence, part of that discovery process when they send you the demand or the request, I should say, for your function report. It could be a report from your a close contact of yours that you noted on your application when they asked about contacts who might be getting the third-party function report for adults. That's also called the SSA 3380. The one that you fill out is the SSA 3373. Occasionally, they'll send out other forms to get more discovery on you. Can you answer a pain questionnaire? Can you answer a headache questionnaire? Some offices do more specific than just the function report. If back when you were at the field office, they had some questions about, in order for them to do a presumed alleged onset date, they need to know quite a bit about your work and certain factors, not so much how you did your work, but was it SGA? When did you stop? Were there gaps? All that business. That's why that's on the application. I recently had a video about some of the questions that seem very similar, but they're really not, about when you last worked on that. But they might send you, let's say you're saying you were disabled 2 years ago, but you've been working part-time, either for an employer under SGA or for yourself, self-employed, and they'll send you another form for a little more discovery on that. That's where you're going to make statements as to your self-employment details. How many hours, did you ever exceed, 45 hours in a month, blah, blah. Or if you're a W-2, some basics about that. Those are the SSA 820 for the self-employed and the SSA 821 for W-2 folks who work for an employer. So that's another form of discovery. Some of that discovery you could, as you just noted, comes at the field office when your application is being worked up to make sure you have they have all those little criteria, because they have to give the DDS like a presumed onset date. That the DDS person, the adjudicator, is supposed to say, okay, I've got to get all the records around that time period, maybe a little before if there are any, all the way to the present. And that's how he does that. That's how he knows what the relevant time period is. What else? Consultative examination, another form of discovery. The SS requests it, and it's in your best interest to attend. That is when they feel they need more to make a decision. And if they don't have it or you refuse, I suspect that would probably be a denial. What else? When they send, this is kind of a discovery thing, I suppose. They send your medical records to their internal medical expert to develop a RFC, residual functional capacity, for you. That is developed, and that is like probably the last, or one of the last things the adjudicator gets back after everything else has been gotten. And that's where the RFC that you've been categorized as having has been determined, and the discovery for that opinion from that doctor has come to the adjudicator, and then he uses that to look at the law and see, what does it say? Are you disabled or not? So that's how discovery works. I always think it's a good idea to stay on top of your own, document your visits, document new providers, and every so often, if it's a new provider, I would tell the adjudicator right away, first time you have the visit. If you're going to be, let's say you have a scheduled surgery in 3 weeks, I'd tell the adjudicator now. If you've had, like, every week you go for mental health therapy, I probably wouldn't be calling him every week, but I might let him know I'm going to have this every week, and then maybe 2 months in, give him a list of all the dates you went, just to keep it flowing, keep him informed, and not make any presumptions. And I would always say, like, if I'm talking to an adjudicator, I would say, if there's anything I can do to help you do your job, aside from the fact that we sometimes send in medical records ourselves, but that's kind of it can be a touchy subject, because you don't really want to send in duplicates. That's frowned upon. It's definitely frowned upon when you're at the ALJ. But those are basically, I would consider that all the discovery process. It's very different from state court, where interrogatories are propounded by you and you have to answer them. Although it's similar to a function report, right? Except state court is all adversarial, where under the rules here, SSD is not supposed to be adversarial. We can all, beg to differ, but they're supposed to be helping you get evidence. You're also supposed to be helping yourself get evidence. Part of that help that you're helping yourself is, yes, in a timely manner, filling out the function report and the work history report when they request it, because they need that information. So another thing that you should know, that there's a difference in, when you go to state court, you can't just go in there, with your personal injury claim and say, here's my medical records. I'm really screwed up and I should get, $100,000. Hearsay. It's statements that were made outside of court that are trying to prove a particular fact that's in those records. That's not admissible, those records, generally speaking. That's why in state court, you have to request the doctor, it could be a subpoena, a friendly subpoena, whatever, to come in, your treating doctor to come in and testify. Sometimes you'll get the doctor to, this is in state court, this is not in the SSA land. You'll get your doctor to provide a written report as to what he'd be testifying about. They're going to charge you out the nose, right? So this is why this is not necessary in Social Security disability. The records are admissible in and of themselves. We don't need to have the claimant come up with 10 grand to bring in his doctor to testify. Or if he paid somebody to give him an exam and write him a favorable opinion, which I don't generally recommend as a general matter. I know some of you have probably done it. But the judge, you're not doing theatrics in front of a jury. The judge knows everything. Yeah, you paid that person for that opinion. How credible is the opinion? Oftentimes less so. Not necessarily, but you run the risk, particularly when the person's ever treated you. How do they really know that much about you? Anywho, discovery in SSA land is cheaper, faster, and really more organic. In state court, it's more contrived, more theatrical, more dramatic, because it's going to be used as it's going to largely be used for settlement purposes, so you never have to pay the doctor to come testify, but you already paid him $5,000 for the report, so it just saves you the other $5,000 or whatever. I don't even know what it's up to now. I mean, I haven't practiced there in over 20 years, but it's such a different animal. It's a nicer animal. Thank goodness those records are admissible from our doctors, because no claimant except the uber wealthy would be able to pursue Social Security disability or SSI. You just wouldn't be able to. It's too expensive. Litigation is highly, highly expensive. So the administrative process, as much as we all complain about it, trust me when I say be glad for it, that it is not where you have to take it to state court. You would be, I don't even know how people would do it, because most people don't have much money by the time they're unable to work. So we have to count our blessings in that way, I believe. Anyway, that's it on discovery, guys. Any questions on that? Definitely feel free to put them down below and I will definitely get to them. All right. Thanks.